If you're a parent living in the UK on a visa, or you're planning to bring your child into the UK on a family or work-based route, there's a new Home Office rule you absolutely need to know about. The UK government has just introduced a fresh set of changes to the immigration rules, and this time, children are directly in the spotlight. These changes affect who can apply as a dependent, what evidence families now need to provide, and how children join relatives who are already settled in the UK. If you get this wrong, it could mean delays, refusals, or your child ending up without a clear legal status. So in this video, I'm going to break down exactly what's changing, who it affects, and what you need to do before you submit your next application. Let's get into it. Welcome back to the channel. If you're new here, this is where we simplify complicated UK immigration law into practical, easy-to-understand updates. No legal jargon, no confusion, just what you actually need to know. Today's topic is a statement of changes to the immigration rules, officially laid before Parliament by the Home Office in July 2026. It's a fairly technical document, 30-plus pages, dozens of appendices, but buried inside it are some genuinely important updates specifically for children and families. The bulk of these changes take effect in early August 2026, and by the end of this video, you'll know exactly what's in them. Let's start with why this update happened in the first place. For years, immigration lawyers and caseworkers have flagged a gap in the system. Here's the problem. Under the graduate route, that's the UK's popular post-study work visa, a dependent could only join the main applicant if that dependent already held permission as a student dependent. Sounds fine on paper, but here's where it broke down. What happens when a child is born in the UK after a parent has already switched from a student visa onto the graduate route? That child was never a student
dependent. They were born here on British soil while their parent already held graduate permission. Under the old rules, there was no clear, rules-based pathway for that child to get lawful status. Families were left relying on discretionary decisions outside the formal rules, which meant uncertainty, extra legal costs, and in some cases real anxiety about a child's future in the country they were born in. The Home Office has now fixed this gap, and that's just the first of several changes worth knowing about. So here's change number 1, and it's the headline update. From the commencement date in early August 2026, a child born in the UK while a parent holds current graduate route permission can now apply as that parent's dependent. Once approved, the child's leave will be granted in line with the parent's own remaining graduate permission, so their status runs on the same timeline. Why does this matter? Because until now, this specific scenario simply wasn't covered by the rules. If you're on a graduate visa and you've had a child in the UK, this closes a loophole that could otherwise have left your child in limbo. It's a welcome, practical fix, and it's the kind of change that shows the rules are finally catching up with real family situations. If this applies to you, my advice is simple: don't wait. Once the provision is in force, get your child's dependent application prepared properly, with the right documentation showing your current graduate permission and your child's birth in the UK. Now here's a change that families need to pay very close attention to, because it raises the bar on evidence. For the first time, children applying under Appendix FM, that's the family visa route, covering partners, parents and children, will need to demonstrate that there are suitable arrangements for their care and accommodation in the UK, and that those arrangements comply with UK law. This isn't a brand new concept in immigration law. It already existed
under Appendix Children. What's happening now is that the Home Office is aligning Appendix FM with that same standard, so the requirement is consistent across different child routes. But here's the catch. At the time this rule comes into force, detailed guidance on exactly how this should be evidenced hasn't been fully published. That creates a bit of a gray area for applicants and their representatives in the early stages. If you're applying for a child under Appendix FM after this rule takes effect, whether that's an entry clearance application from overseas or a leave to remain application from within the UK, expect to be asked to show clear evidence of where the child will live, who will be caring for them, and that those arrangements meet UK legal standards. My recommendation? Start gathering this evidence early. Tenancy agreements, statements from carers, school enrollment letters, GP registration, anything that paints a clear, documented picture of stable, lawful care arrangements. Change number 3 is about Part 8 of the immigration rules, which governs family reunification. Previously, if a child wanted to join a close relative, someone other than a parent who was settled in the UK, the case largely depended on proving serious and compelling circumstances. That's a high, subjective bar, and it left a lot of room for inconsistent decision-making. Under the new changes, Part 8 has been clarified. There's now a more defined route for children whose only family connection in the UK is a settled close relative, rather than a parent. In these specific cases, applicants no longer need to prove exceptional circumstances in the same way. Instead, the rules set out a clearer, more predictable pathway.
That said, and this is important, several immigration practitioners have already pointed out that the drafting here is dense and in places open to more than one interpretation. If you or a client are relying on this route, don't assume it's a
straightforward tick box exercise. Get proper legal advice and look closely at how the specific wording applies to your situation, because the practical effect may not be as simple as the government's own explanatory notes suggest. There's also a lesser-known but important fix relating to protection status. That's refugee status or humanitarian protection. Since March 2026, protection status has generally been granted in 30-month blocks rather than longer grants. That created an unintended problem. A partner applying under Appendix FM could end up with permission that runs longer than the protection sponsor's own leave. In other words, the dependent partner could still hold valid status even after the main applicant's protection leave had expired or been refused. The new changes fix this by aligning the partner's permission to expire on the same date as the sponsor's existing grant, whenever the sponsor holds a 30-month protection permission. It's a technical adjustment, but it matters because it closes a mismatch that could have caused real confusion and potentially compliance issues for protection-based families. Now, it's worth stepping back and putting these child-specific changes into context because they're not happening in isolation. The UK is in the middle of a much larger overhaul of its settlement system. Back in November 2025, the government proposed extending the standard qualifying period for indefinite leave to remain, ILR, from 5 years to a baseline of 10 years under a new earned settlement model. That proposal went through public consultation, which closed in February 2026, and it's still being finalized, with implementation now expected later in 2026 rather than the original timeline. Here's the part that matters most for anyone watching this with children in mind. The government has openly acknowledged that children raised in the UK, especially those who spent their formative years here, may need different treatment under
this new system. Whether special transitional protections will apply to that group is still under active consideration. As of the most recent public updates, this has not been finalized. So while the changes we've covered today are real, confirmed, and already law, the wider question of how the 10-year settlement model will treat children long-term is still an open one. That's a space to keep watching closely over the coming months. Let's bring this together into practical steps. If you're a graduate visa holder with a UK-born child, start preparing your dependent application, and make sure you have clear evidence of your current graduate permission and your child's UK birth. If you're applying for a child under Appendix FM, begin collecting detailed evidence of care and accommodation arrangements now, even before formal guidance is published, so you're not caught off guard. If you're relying on Part 8 to bring a child to join a settled relative, get specialist legal advice before you apply. Given how dense this drafting is, a second set of expert eyes can make the difference between an approval and a refusal. And across all of these routes, timing matters. Applications submitted before the relevant commencement date will generally be decided under the previous rules, while anything submitted after will fall under the new provisions. So if you're unsure which set of rules will benefit your case more, that's exactly the kind of question to raise with a qualified immigration advisor before you submit. To sum it up, the UK has rolled out a meaningful set of changes affecting children across the graduate route, Appendix FM, and Part 8 family reunification, closing real gaps that have affected families for years while also raising the evidence bar in some areas. These are not proposals. These are confirmed changes to the immigration rules, and they are already taking effect. If any of this applies to your situation, don't leave it to the last minute. If
you found this video useful, hit like, subscribe, and turn on notifications because we'll be covering the next stage of the UK settlement reforms as soon as more details are confirmed, including how children may be treated under the new 10-year ILR pathway. Drop your questions in the comments. I read every single one, and I'll see you in the next video. This video is for general information only and does not constitute legal advice. Immigration rules are complex and case-specific. Always consult a qualified immigration solicitor before making